Hi, so my name is Matt Bogosian. I am a certified family law specialist here in California. I've been practicing for almost 15 years. I also worked as a law clerk for almost 5 years before that at various family law firms in Beverly Hills and Los Angeles, working on extremely high-end cases, celebrity-type cases. And so very early on in my career, I got exposed to the Court of Appeal and attorneys who would file papers this thick that judges often wouldn't even have a chance to read. And through the process of that, I learned a lot about what works in court and what doesn't at what I believe to be the most important part of a family law case, which is the preliminary orders phase. Temporary orders set a precedent in your case. You're talking about the very first custody and visitation order, the very first child support order, the very first spousal support order, an initial order for attorney's fees. These are critical parts of the case. I find that this is 60 to 70% of family law practice is just dealing with temporary orders. So it's an honor for me to be able to present to you some nuggets of information that I've learned along the way that hopefully will help you succeed at a greater level with your temporary orders, both getting them and defending against them, because you find yourself sometimes coming to the office, the mail comes in, and you just got slammed with a massive motion, and you've only got 2 weeks to get ready for this. And so I'm going to give you some tips on how to get through it. Logistically, we have a new form that we use for temporary orders called the request for order. Historically, we would use orders to show cause and notices of motion. They worked a little bit differently, and now we have one longer form that not only incorporates elements of both of those forms, but also incorporates the application for order and supporting declaration that we also used to use. So everyone's using the FL300. I prepared an outline for you that includes references to the form numbers and references to rules of court and the family code, so that you can go back and look at it. If you ever need a quick reference guide, it's a great checklist for you, because sometimes just off the cuff, you're going to have to go in and prepare either the request for order or respond to one. And there are so many new attachments they've created. A lot of this emanated from a California Supreme Court case, Elkins versus Superior Court, came down in 2007. And the Elkins Task Force was an assemblage of attorneys and judges who came together and decided to make family law procedurally more user-friendly. At least that was the goal. And I think they succeeded to a large extent by simplifying and improving a lot of the forms that we use. Now, the request for order has both lines for an attorney signature on the front and the client signature on page 4, which is different than before. We used to have a notice of motion just signed by the attorney and an application for order signed by the client. Filing of the request for order is required before service. So previously you could do a notice of motion, serve it on the other side, and you didn't have to file it. You have to file the request for order before you can even serve it. And the request for order, when it's filed at the filing window, like an order to show cause, will require the clerk to set a date for you. And so if you have certain calendar conflicts, or you know of calendar conflicts of opposing counsel, make sure to clear those if you send these out with an attorney service, so that you actually put down your requested dates in advance. And you might get lucky and get one of your preferred dates, because if you just send it down for filing, you're going to get it back with whatever date the clerk sets that's available for the court. And if it doesn't work for you, it is not easy to resolve. So I definitely recommend making sure that whoever goes in to physically file that request for order is very clear on what dates work and what dates don't, so that they can coordinate that in advance. Also, if child custody and visitation is at issue in your proceeding, mandatory mediation is going to have to get set. That mediation date is going to have to get cleared in advance, and it's going to have to be included on that request for order form. So be sure to understand the procedures within the court you're working in. In Los Angeles, it's called conciliation court. In Ventura County, it's called mediation, but in essence, it's always required, and it's always required to be included on that request for order form. So be sure it's there, and be sure that your client is aware of that mediation date, because sometimes that mediation date is not the same date as the hearing, and they need to make sure they go, because if they don't go, often the case won't even get heard. The judge will just continue it. The supporting client declaration. This is a critical part of requesting an order. It's often done haphazardly. I have seen declarations written purportedly by opposing counsel that contain nothing but hearsay, no foundation, ranting and raving. Be very careful when you're doing declarations. Don't just tell your client to send you a big long email telling them about a particular issue. You need to be very careful editing these declarations out, because you will find in family law the clients have a lot of anger, animosity, and venom. And if that seeps into the tone of your client's declaration, it's going to make a negative impression on the court. And if you learn anything in family law, the facts and the law are important, but equally important is the psychology of the case and whether or not the judge likes you and or your client. Never dismiss the likability factor. You can go through the last 30 years of presidential elections, and if you look at each presidential election, it was largely a contest of likability on who won and who lost. It really wasn't won or lost on issues in most of those cases. And the same thing happens in court, especially in custody cases, but virtually every time you go before a court, you want to make sure that the tone of the client's declaration is positive, that it includes facts and nothing but facts, that the client has firsthand knowledge of, and try to avoid any hearsay. What you want to do really is you want to have any kind of documentary evidence set forth as exhibits and attached to the declaration so that it lends more credibility. Don't just expect the judge to take your client's word for something. Try to get documentation and exhibits well in advance. And you don't always have a lot of time to do this, so make sure that your client comes to your office. If you're going to sit down and prepare a request for order, think about in advance what types of documentation might be useful in court to prove up your case, and have the client bring it with them so that you can attach it as exhibits and physically incorporate those into the declaration. There is a 10-page limit now on declarations, thankfully. I had cases in the past where I would get a 30-page declaration from the opposing side. I wouldn't even know where to start to respond to it. So we have a 10-page limit. That's Rule 5.111 of the California Rules of Court. I highly recommend using headings for organization in your declarations. The judges often do not have the time or make the time to review your papers before the court date. Many judges will go through their calendar on the day of the hearing to even see who's there, who's not there, and once they've determined who's there, who's ready to go, and who hasn't settled, they will then go back to your file and say, okay, I'll take you after the break. They will then go and read your papers in a 5-minute time frame. And if you don't have clear headings and possibly maybe a statement of what the following 3 paragraphs are going to say, summarizing each step, you may not get read. But if you do, and you've broken it down and it's clear, and resist the temptation to maximize that 10-page limit. Try to get your declaration somewhere in the 3 to 5 page range if there are limited issues, 5 to 7 pages if there are more complex issues, and make sure you've got headings in there. The judge should be able to flip through in 5 minutes and get the gist of what you have to say. If it's wordy, try to break it down. I heard one appellate justice giving a writing seminar, and he said, always think to yourself, if I just had more time, I could make this shorter. And use that approach because it really works. And like I said, keep the tone positive and objective. Make sure you're clear on what it is that you're asking for, and be clear on what it is you're asking for and why. A lot of judges are surprised when they read documents and they still can't figure out what is being asked for. I get requests for order all the time by opposing counsel or self-represented parties. I can't even figure out what they're asking for. So be very clear if you're requesting an order, what you're asking for. Attorney and/or third-party declarations. This is a critical part of a request for order because I remember my first court appearance. I was in Orange County. The judge took us back into chambers and said to both lawyers, I've read all the papers and I'm getting sick and tired of this he said, she said, and I won't use the next term. And he said, now you guys go out there and settle this case or I'm going to make both your clients' lives very difficult today. True story, really happened my first day in court. It taught me a lesson that they really don't like the he said, she said of the individual parties. However, third parties have a lot more credibility. So if there happens to be a third party that has anything to say that's relevant to your case, no matter how short or insignificant you think it is, consider including it. But be careful as well. Clearly, attorney fee requests should always have an attorney fee declaration. Marriage of Keech laid that out, but we now have Rule 5.427 of the California Rules of Court. Read that very carefully when you do a fee request. You're going to want to include the attorney's education, training, and experience. And in that regard, I always recommend having a pre-prepared attorney declaration. If you're a paralegal, you should have your attorney's information, educational background, years of experience. Always update that as well because those years keep accruing. And make sure you've got really a pre-prepared attorney fee declaration with the rate and everything else ready to go because you may not have a lot of time to file that. You know, you may have a client where you have an ethical obligation to get a support request in and you want to squeeze in a fee request. You better have a fee declaration virtually ready to go where all you have to do is plug in the work that needs to be done. The work performed and anticipated has to be included. So if you're asking fees for what has already been done, you're going to want to include redacted billing statements and or at least itemize in the declaration the work that's been done, the hours and the amounts, and work that's anticipated. Often we're requesting fees going forward. Be very specific and concrete about what you expect needs to be done. Include all efforts to resolve issues. Judges love it when you try to settle a case. So if you've already made settlement efforts, not only with respect to the request you're making there, but just in general, make that clear to the court and explain that you're really trying to work this out and not just drum up a bunch of fees. They appreciate that and they're probably more likely to award you fees if they see that you're there to try and resolve it and take some work off of their desk. Also, if the other side has not been helpful, you don't necessarily have to request sanctions under Family Code Section 271, but certainly under a basic need-based fee award, it doesn't hurt to include the fact that the other side has run up a huge fee bill by sending a lot of discovery that wasn't necessary or sending you nasty letters. If they have really negative tone, whether it's a pro per or an opposing attorney, I love to include in my attorney fee declarations nasty letters from the other side. I love it when I get nasty letters. Some people get annoyed, they get upset. I have clients who get really upset when either their soon-to-be ex-spouse sends them a nasty email or opposing counsel sends a nasty email or letter. I tell my client, rejoice, rejoice, because now we get to include this in our temporary order opposition or papers, and we get to make them look terribly bad before we even walk into court. The judge will probably hate the lawyer or the opposing party before we've even walked in. Isn't this a blessed day? And you really have to think of it that way. Once your client starts to see that nastiness from the other side can actually just make them look good in court, they'll be less likely to respond in kind. And so you have to train your clients about emails. You have to train your clients about text messages. You have to train your clients not to get upset when opposing counsel's nasty. We're going to deal with it. But it's not in your best interest for me to run up a huge fee bill and respond to every little thing that I get in from, Wacko Jacko, who's sending, sometimes you'll have a pro per on the other side, sending you 6-page emails every other day because they've got nothing better to do and they're not paying anyone for it. And you don't do your client a service by responding to everything. You're egging them on. There are some great books. Bill Eddy is a wonderful author teaching you how to deal with high conflict people. hopefully not your client, but certainly on the other side, you're going to get it. And you don't want to constantly respond. The sooner you respond to some nasty communication, the sooner you're then going to get a response right back. So if you don't want to be flooded 24/7, take your time, because chances are the next day they're going to find some other fish to fry and forget all about the nastiness they just gave you. But it's great to include in your request for order attachments, because it's not hearsay if the other side goes ahead and makes an admission by a party opponent. There are so many exceptions. So you're almost always able to get into evidence something really nasty that was said on the other side, whether it's and if it's a lawyer who sent you a really nasty letter and you're doing a fee request, put it in bold in your declaration what was said. Attach the letter as an exhibit, but put in bold anything really nasty. I do bold and italics anytime the other side did something nasty. So even if the judge only has 2 minutes to read your papers, they're going to zero right in on all that nastiness. And I'll tell you, you can try to build yourself up all you want, but polls have shown, even in politics, that positive campaigning is not as powerful as attack ads. That's why there are so many of them. They really work. So rather than be the victim of attack on your end, make sure your client's wearing the white hat. I tell my clients, before you send an email to your ex-spouse, I don't care what the issue is, send me a draft first, let me review it, let me edit it, and then we'll send it back. And then you can use some of that correspondence as attachments in your temporary orders, whether it's custody or support or any other issue, and all of a sudden your client looks good because the judge will scrutinize those and say, so this person was really friendly in the email and this person was really nasty. Good guy, bad guy. And they usually do put a white hat on one client and a black hat on the other, and you want to make sure your client is clean as a whistle. It makes it so much easier when you go to court, because a lot of times there are minor issues that are judgment calls, totally discretionary with the court, never going to be reversed on appeal. And a lot of times these judges, as my predecessor was indicating, have no experience in family law. Many of them are appointed, they get a 2-week training course, they have never done a divorce in their lives, and they're ruling really by the seat of their pants and how they feel at that particular moment about a person or an attorney. So just keep that in mind, that the psychology of the case is far more important in family law than probably any other area, and it's all about likability. And I think if you hammer that home, don't make your declarations too long, don't seem overly litigious. Your clients are going to want everything to be talked about, everything to be included. Edit it down, pare it down, keep it short and sweet, and put yourself in the shoes of a judge who's got 30 cases a day. Give your client some realistic assessments of what court is all about. Many clients come to us really wanting to go to court. They don't want to settle because they just don't like their ex, and they think that this whole process is just a great way to get back at them. What they don't realize is that while they think their case is Roe versus Wade, the judge has 30 cases a day. You're a hamburger and hot dog in a drive-thru, and they don't get that. The courthouse has become DMV with robes, okay? So they need to understand right away that if they're going to pay you to drive to court and drive back, you're probably going to be sitting there for 3 hours. If you're lucky, the judge will give you 5 minutes, only to tell you, I don't have time for your case, come back in 3 more months. Your clients need to understand that in advance, because they're expecting you to get them quick results. The fact of the matter is, if you go through the standard litigation process, your likelihood of getting results goes way down when you go into the abyss of the courthouse, because that's what it's really become. Third-party declarations other than attorneys, very important. Forensic accountants. Let's say you've decided this case financially is a little bit over your head, maybe over the judge's head, and there are some really sophisticated issues that require a forensic accountant. What might those be? Business valuation, as well as cash flow for support. If you're trying to get support from someone whose tax returns show losses and they're driving a Ferrari, it's time to get an accountant. But you need fees for that. So you want to make sure that you have a forensic accountant declaration on hand, ready to go at all times with the date blank. Very good tip for you. Develop a good relationship with a forensic accountant who has a standard fee agreement and a standard declaration pre-prepared for you that you literally can just call him up on the spot and say, and if you're really smart, you can get him to sign these in advance. And you can be in a hurry attaching a fee agreement for a forensic accountant that's already prefabbed. And your likelihood of getting that award is much higher than if you're on the phone calling and you're trying to get the declaration, or you don't have a declaration at all, and you as the attorney are trying to explain to the court what forensic accounting work is needed. It's really difficult to do. So I recommend having a prefab declaration ready to go from a forensic at any given time, and just have a pile of 5 of them. And that way, if you ever need one, you've got it in a hurry. Vocational experts. Now, let's say the other side isn't working. They're either unemployed or underemployed. Happens a lot. The typical approach is, let's do a vocational examination. Well, you either have to get a stipulation to do a vocational examination, or you have to file a motion for one. That takes a long time. Usually they won't stip to them right away. And even if they stip to them right away, it can take 30 to 60 days for the report to be completed. And then what is the report? Nothing but hearsay. You can't get it in. You're going to have to create some mini trial. So it's really not of use to you for at least 3 to 6 months, the vocational examination. So I did something a little bit more creative in a case about 2 years ago, and I've been doing it ever since with success. I called up a vocational expert. This happened to be Susan Miller. And I said, Susan, here's my problem. I am defending against a request for order for spousal support from husband. I represent wife, and he wants money out of her, and he's just been sitting essentially on his rear for the last 2 years, hasn't been doing anything, but has a history of making over $100,000 a year. Help me out here. If my client told you everything about this guy, his history, his educational background, his earnings from before, could you do a declaration for me saying that if, assuming these facts are true, this is what I think he can earn as a defense against his support request? She said, absolutely. Cost nothing more than $1,200. I got a full declaration, 4 pages long, completely analyzing everything. And here's the beauty of it. Experts are allowed to rely on hearsay in order to formulate an opinion. So everything gets into evidence. What ended up happening? It settled very favorably for my client, primarily because of that declaration. And if I had to take it to hearing, at least the judge would see the vocational expert's information and declaration. I can bring, if I don't settle the case, I can always bring that expert in, or I can set an evidentiary hearing later, and retroactivity is preserved. So now all of a sudden, I've set a date in the future where my expert can come in. I can always say at the hearing where they're requesting support, oh, Your Honor, I think we're going to need at least 3 hours for this evidentiary hearing. That'll get their support request kicked out quite a ways. So it's a good tip to have that declaration, though, if you can. A nice vocational declaration. Also, think about a custody expert. If it's a really highly contested custody case, consider having a PhD custody analyst maybe do a declaration for you. Have them review. Again, they could rely on hearsay. Have them review the facts of the case, and maybe they have a recommendation they can make to the court independently. You don't have to rely on an independent Evidence Code Section 730 expert to give information to the court on a custody issue. You can have a hired gun do it for you and make a recommendation. It doesn't hurt, and the other side isn't going to think of it in most cases. But I've had cases where it really helps. So, and again, it's a lot cheaper than a full-on custody evaluation, but gives the court the impression that you're on your A game and you've got third parties on your side who are willing and able to testify on these issues. Really makes a nice impression. And it also scares the other side because they might realize that in addition to an independent 730 evaluation, you might even have your own hired gun interview them as well. And now you've got a little bit of a buffer zone if you're going to be in a custody evaluation. Always have your own expert too. If the client can afford it, it's worth it. And a lot of clients, when they are explained that their children's lives are on the line, and this custody case is on the line, and if you've got substance abuse issues or domestic violence issues that are really serious, that's definitely something you want to consider. Of course, in every custody and visitation case, you have to explain to your clients that joint legal and physical custody tends to be the rule. These days, sole legal and physical custody tends to be the exception. In the absence of people living really far apart, in the absence of domestic violence, in the absence of serious documented substance abuse, most judges are going to take either 50-50 or 60-40 as a default. And if your client wants any better than that, you're going to have a big burden of proof. And before they spend a bunch of money on custody litigation, they need to have a realistic assessment that that tends to be the ruling. You're going to have to build a pretty strong case to convince the court, because the judge isn't going to go, oh, it's the mom, female, she's obviously entitled to more time. Absolutely not the case anymore. So you really have to explain to the judge in your declarations why a particular timeshare schedule is in the children's best interest, and it better not be just because. Or if your client's response, like many of my clients' response to my question, here's the question. Why do you think you should have more time than the mother or father? And the answer I get sometimes is, he's a jerk, or she's awful. Well, that's not going to fly in court. That's not a legitimate basis, because we have frequent and continuing contact with both parents. And you need to tell that to your clients. You know, a lot of family law is just managing client expectations. The lower their expectations are going into the process, the more sobering your meetings with them are, the more likely they're going to be pleased with the end result. I try to give my clients their worst case scenarios up front, well in advance, even before they have hired me. I want to tell them in my initial interview with them what their worst case scenarios are, so that if they're still willing to take it on, great. But if their expectation levels are such that they won't even hire you or have you represent them, if their worst case scenario may actually in fact play out, and they'd rather go to somebody who can sing them a song and give them a great story, and then have them only woefully disappointed in the end, that's great. Let the other lawyer have these nasty YouTube videos about them, about how they promised them the world and it was a disaster. But don't be the guinea pig for their experimentation in the legal system they know nothing about. You know that anything can happen in court, so they need to know that too, and they're far more likely to come to a sensible decision if they know that if going into court, they could lose custody. A lot of parents don't think for a second, that especially moms, they don't think for a second that they can walk into a custody hearing and lose custody if they're the ones always taking the children to school. They think that, you know, that should just give them a shoe-in, or that that's always the way it's been. Now, I've seen judges actually reverse custody completely just to restore the relationship that isn't working. Now, the relationship that isn't working may completely be the fault of the other parent, but the presumption is there must be some parental alienation going on, and if your client's declaration, again, is talking about why I should get custody because that person's so awful, you're really going to lose a lot of points. Judges look very negatively upon personal attacks. However, if there are specific facts, specific things, concrete, that are provable, that the other side has actually done or said, that's where you're not attacking. You're not giving opinion. You're not calling him a jerk. You're just quoting the jerky thing he said. And that's fair game. That's what you should be doing, is focusing on the nastiness that's documented in writing. Okay, there's Facebook, there's email, there's texting. It's almost impossible to go through a few months in a family law case where somebody isn't writing something nasty that's documentable. So make sure you've got that in, but don't do the name calling, don't do the opinions. In fact, you should probably go out of your way to make your client sound positive toward the other parent. He's a really good father. I think he deserves quality time with our children. I just feel that it's not in their best interest to be exposed to such negative energy. Case in point. That's the approach. As far as other witnesses, be careful. Friends, family, and here's the best one, new mates. How many times have you had a case where your client isn't really just the client? They've got a new girlfriend or a new boyfriend who's decided to be their other lawyer. And they've decided they know what's best for their significant other. Now that person has a lot of ulterior motives. Does his new girlfriend really want him to pay support to his ex-wife? I don't think so, right? So this is a real bone of contention. Or does his new girlfriend really want him there at the visitation exchanges? This really gets into contentiousness. And I find cases where I'm trying to give advice to my client, and they're saying, hang on a second. Hey, honey, what do you think? He's saying I should settle, but basically I'm going to have to pay like $1,000 a month. What do you think? And then you just hear this screaming on the other side, and you're just, are you kidding me? And so you have to coach them to really extricate their new mate out, because the fact of the matter is if the new mate is too involved, it's going to create a problem for you. You're never really going to be able to settle the case, and so it's not enough that you're going to convince your client of what's in his or her best interest. You now have to convince this other person, and it creates a mess. So early on, if you find out that you've got a client with a significant other, coach them. Number one, don't discuss your case with your significant other. They won't do it, they won't listen, but at least coach them and maybe they'll minimize it. Tell them that all of your discussions are attorney-client privilege, and anything they reveal to anyone, including their significant other, could constitute a waiver of the attorney-client privilege, and I may have to completely withdraw if they find anything out. That should minimize it. But what really happens is they want to do a declaration. Yes, boyfriend and girlfriend want to explain how nasty mom was at the exchange. I saw her do X, Y, and Z, and they really want to get involved. Now, be careful. This could give rise to what happened to me in a case where I didn't do that declaration yet, but before I even thought about the role that the girlfriend might play, the girlfriend got subpoenaed to a deposition. Okay? Because the girlfriend apparently was a party girl, and these people were heavily into alcohol, and this was an issue in the custody case, and they wanted to take her deposition. And she was freaking out. She didn't want to get she wanted to have complete say over what her new boyfriend would settle on and what the results of the case would be, and possibly even doing a declaration. But she certainly didn't want to get dragged in on a work day. So you can't have your cake and eat it too. So if this significant other really is playing a strong role, sometimes there is value in it. Sometimes the significant other has developed a relationship with the children. Sometimes the significant other is a fiance. They may actually be a better role model for the kids than the actual parent. So sometimes, and you have to play it out, and you have to see what is the personality makeup. Again, it's a likability contest. If this significant other is a raving lunatic, keep them away at all costs. If the significant other is a model person that you almost wish that were your client, you may want to bring them in because they might be more effective an advocate than your own client is. So do a personality test, but be very clear you're not representing the significant other, and try to keep discussions where they want to bring their significant other into your office, and try to keep them away at all costs, because it's a waiver of the attorney-client privilege, and quite frankly, it's not in your client's best interest to drag their spouse into their divorce case. It's very messy, and it doesn't really help their relationship, because then what happens is they just start fighting with each other as your client's trying to make decisions that make sense for him or her, and they're in conflict with what they would ideally want. It's really none of their business. Other attachments on the request for order. FL 311 is a child custody and visitation attachment. Tell the court what timeshare you want. That's right in the attachment. FL 316 is a neat one. This is an attachment where the other side hasn't done a proper declaration of disclosure. You've already had some talk already about discovery and declarations of disclosure. Well, you can do a motion under Family Code Section 2107 saying the other side hasn't complied and hasn't provided a sufficient final declaration of disclosure, and here's an attachment about that and some relief you can request, precluding that. It's essentially a motion in limine that you're now allowed to do, and this is all part of the Elkins rules and all that. So take a look at FL 316 if you feel like the other side hasn't done a proper declaration of disclosure, and it happens a lot, you'll get a schedule of assets and debts that has no attachments, that has nothing on it whatsoever. And this is a wonderful opportunity for you to expose to the judge how the other side just doesn't have their ducks in a row. It's just a great way to get an edge on other temporary orders that you're requesting when you show that the other side isn't complying. The spousal support attachment, FL 157. If you're requesting spousal support or you're defending against spousal support, use FL 157. It lays out the section. It lays out Family Code section 4320 in its entirety and breaks it down item by item by item. I highly recommend using it in any spousal support equation. Even if it's a temporary order where you're probably going to be using guidelines, it's always good to go through the 4320 factors, especially if you're going to ask for a deviation from guideline. And you can ask for a deviation from guideline even at the temporary order stage for spousal support. Let's say the person requesting spousal support is now cohabiting with a significant other. Wouldn't that be a great reason to request a deviation from guideline? Absolutely. I've had income and expense declarations come in where they admit that their significant other pays half the rent. Wonderful. No reason to get stuck with a guideline spousal support order when she's effectively married in all but name. The income and expense declaration, FL 150, is the single most important document in a temporary order request on any financial issue, whether it's child support, spousal support, or attorney's fees. I can't tell you how many times a temporary order on financial issues was won or lost on the income and expense declaration. Be very careful when you do these. I'm going to give you a tip. If you take nothing else from today, make this part of your practice. Do the schedule of assets and debts before you do the income and expense declaration. You already have to do a preliminary declaration of disclosure anyway in a typical divorce case. If you have a paternity case, you can usually get off the hook not having to deal with property declarations, but I've even had some judges demand them even in paternity cases. But in every divorce case, you're going to have to do that preliminary declaration of disclosure at a minimum, and possibly a final if it's not waived. If you have to do it anyway, why not go ahead and do that schedule of assets and debts at the same time that you're doing the income and expense declaration? Otherwise, if you wait another 60 days to do the preliminary declaration of disclosure, you're going to have to update the income and expense declaration, get all new pay stubs all over again, and some of the facts may have changed. You're doubling the work and you're doubling the expense for your client. More importantly, the real reason you want to do the schedule of assets and debts at the same time and actually do it first is because on page 2 at item 11 of the income and expense declaration, you're asked to include under penalty of perjury your client's assets. They are broken down into 3 categories, A, B, and C. If you add up A, B, and C, they correspond completely to the entirety of the schedule of assets and debts. What happens in most cases? You won't think about the schedule of assets and debts because you're in a hurry. You want to get this request for order out. So what do? You just go through 11 A, B, and C with your client. How much do you have in cash and checking? Oh, probably about $1,000. How much do you have in stocks and bonds? Maybe about $10,000. And how about property? Nothing. Okay. Then you do a schedule of assets and debts. If you do it later, boy, are you going to be surprised. Make sure your client gets a blank income and expense declaration and a blank schedule of assets and debts at the outset of representation. I send it with my fee agreement in an email as an attachment, and I tell them immediately, I need your last 2 months' pay stubs, and I need deeds and current statements for your mortgage, for all of your assets, all of your debts, everything that you have, retirement accounts. I want the current statement. You'll be shocked when you get all of the documentation. It won't sound anything like their ballpark estimates on 11 A, B, and C. So do the schedule of assets and debts first. I'll get to questions later. Yeah, but I'll definitely take you up on it. So make sure on the schedule of assets and debts that you lay it all out, you put it in, you do your declaration of disclosure, then work on the income and expense declaration, scrutinize those pay stubs, make sure that the income you're putting down is accurate. If your client is self-employed, you've got an even bigger problem. But at least if you've done the schedule of assets and debts first, your 11A, B, and C should be clean. You never want to have to be determined or unknown or NA or plus or minus. No, get it down to a science. And if you do the schedule of assets and debts, then you're going to be able to do 11A, B, and C down to a science, and you're going to look great. Or if you're a paralegal, your attorney is going to look great, and they're not going to be embarrassed in court when on cross-examination the other attorney goes, wait a minute, you put down this for your assets, but your schedule of assets and debts is completely inconsistent. How do you reconcile that? Well, they're both under penalty of perjury. And if they're signed on the same day and they match, your client's off the hook. But the minute you do the income and expense declaration, even 2 weeks later, those asset values are going to change. So do the schedule of assets and debts first. It's extra work at the front end, but it's going to save you a headache at the back end because you're off the hook. And by the way, if you've done your preliminary declaration of disclosure and you have filed the FL 141 declaration regarding service in connection with any request for order, defense, or offense, you're smelling like roses, because how many times has the other side not done a declaration of disclosure for months? And here you are at the outset of the case. The judges sometimes just scroll through the file to see what's going on. Just because they have nothing else to do, they're looking around, they go, hey, you haven't done your declaration of disclosure. The other side has. Brownie points right off the bat. You are on your A game. You've gotten everything out of the way. And also, the schedule of assets and debts may be important to some of these financial issues, such as attorney's fees. So it's important to know. There may be assets your client doesn't even know about until they start digging up the paperwork. I've had some cases where my client doesn't even know what they have. And I have them. I said, just go into the house before. And I have some people coming to me before they've even filed for divorce who know nothing. I tell them, before you even let the other side know you plan to file, get your ducks in a row, get some paperwork, get your hands on things, develop some financial knowledge, because you don't want to be in a situation where everything just suddenly disappears and your client's missing out on a lot of money. Proposed DISO master, very important to do. But before I get to that, I do want to fill you in on a red flag. I talked a minute ago about the self-employed client. This is the most dangerous part of a request for order or defending against a request for order, is when you have a self-employed client. Self-employed clients are an interesting mix of people. Self-employed clients typically love to take out loans for their businesses and show lots of income when they fill out rental applications and loan applications. But they hate paying taxes. So when they do their tax returns, they like to show losses, even if they're driving a Ferrari. So you may have a situation where your client's expenses are $10,000 a month, but he's only showing income of $2,000 a month. This is the single biggest red flag. Not every judge is sophisticated, but almost all of them within the first 2 weeks start to realize there is rarely a correlation between a person's expenses and a person's income on their income and expense declaration. Screen this out in advance, scrutinize it, talk about it candidly with your client that this is going to be a problem. And this is a good reason to settle your case, because I've got your Schedule C and I've got your expenses, and they don't even come close to matching. So clearly you're either taking in cash income you're not reporting, or we need to pare down some of these expenses. Maybe your client fills out the income and expense declaration thinking if they put really high expenses, the judge will feel sorry for them and they'll look good, when in reality the judge just imputes that as income to them and they get hammered for it. So I always tell my clients, keep your expenses relatively low, especially if you're going to be representing the payor or potential payor client. You want their expenses to be down to a minimum. Be sure to check all 3 boxes, which are actual expenses, estimated expenses, and proposed needs. The reason I check all 3 boxes is, number 1, they let you, and number 2, if at a hearing there's ever a question about a particular expense, you can always hedge it by saying it's this, this, or this. Okay, so at least you've covered yourself, because it's not a science. You're doing this in a hurry, and sometimes there are questionable expenses where your client's literally giving you an estimate off the top of their head, and it may be completely off base. You don't want to get hammered on cross-examination or have your client hammered on cross-examination. But be very careful when you've got expenses and you've got income and they don't match. Your client has a problem, and I've had real frank, hard discussions, and I've had to really go through their tax returns and go through their expenses and try to figure out how we can present that income and expense declaration in a way that won't look ridiculous. Sometimes it's a real challenge, but you have to have those discussions, and you really want to encourage those clients to settle, because you really don't want them going under penalty of perjury in front of a judge where their tax returns really aren't legitimate. Filing and service procedures. Like I said before, the request for order has to be filed before it's served. Mediation or conciliation court date. Service requirements. You probably all know this, but 16 court days before the hearing, it has to be personally served. So if you're going to be serving these things by mail, further out. If you're at the beginning of the case, you're going to have to personally serve this anyway. So right along with the summons, right along with the petition, go ahead and serve that request for order. Get it all done in one shot. If the responding party has not been personally served in the case, you definitely have to do that. And be sure to file your proof of service. This isn't a notice of motion anymore where the proof of service is automatically attached. And this isn't a document where you can attach a proof of service at the back because you have to file it first. So you need to file a separate proof of service on caption pleading and or using the judicial counsel forms. And so be sure to file that. You have to file that 5 days before the hearing, but I always recommend filing it as soon as possible right after service. If you show up to court and the other side doesn't show up to court, even if you really have served it, if there's no proof of service, it's either going to get continued or taken off calendar. So it's a very important point that I can't tell you how many times gets missed by the other side. Responding to a request for order, and then I'll deal with any reply. Responding to a request for order, you're going to use the responsive declaration, Form FL320, an income and expense declaration, again, if there are financial issues, a memorandum of points and authorities. This is an interesting point. If you're the moving party, I do definitely recommend doing a memorandum of points and authorities. Bear in mind that most of the judges don't have a lot of time. So try not to make these lengthy. Make them short and sweet. Get to the point, bullet point it for them. Same thing if you're doing a responsive declaration. I don't recommend doing points and authorities more than 2 or 3 pages long. I've done some that are 1 page long that have 5 bullet points and a quick conclusion, where I don't do summaries, I don't do even the facts of the case. I'll just hit the bullet points because they don't have a lot of time. But if your case is one of these mega cases where you think you may be going to the Court of Appeal, then do a beautiful one because you're going to need it. Anything that you don't include law-wise as an argument in the court below is effectively an argument waived on appeal. So if there is a strange issue, a new issue, a novel issue, or a point you want to make, it doesn't hurt to throw in a quick points and authorities, even in a responsive declaration. I do it quite often, especially when the relief requested is a little bit unusual, or I've got case law or statutes that can beat it. Proposed disso master, ex-spouse, or support tax. Both in the moving papers and in the responding papers, if child support and or temporary spousal support is at issue, always, always, always include a support calculation in your moving or responding papers. The reason is the judge doesn't have a lot of time, and you're far more likely to get your disso master entered as the order than the other side's if you've got one and they don't. So be sure to include one. It also facilitates settlement because you can, if nothing else, narrow down the issues in dispute that go into the program. If there are possibly multiple inputs that could go into the disso master, include 2 or 3 alternatives. Go over them with your client. If you are going over proposed disso masters with your client, I always recommend running their worst case scenario first. Get their expectations down. The worst thing you can do is bring a client into your office and in your excitement, exuberance, and zealous representation, you automatically begin the best disso master possible with the highest income for the other side, the lowest income for your side, the highest timeshare percentage for your client, even if it's not been determined. And all of a sudden it spits out, oh, you're going to get $5,000 a month. When the more realistic number may be $2,000 or $3,000, you've just done yourself and your client a disservice because you're going to be upside down and negotiating against yourself, and your client's going to say, well, it's a computer program, and it says, as if it's a human being, look, I'm supposed to get $5,000 a month. I don't understand why you're telling me I should only accept 2. So do the worst case scenario first so they see that. I'd rather have them gulp a little bit and say, wow, I don't think I could live off of that. And then you can say, well, we can play with these numbers a little bit, and the judge has discretion with some of these things. If we can prove this, it might go to this. If we can prove this, then it might go to this. But always show them the worst case scenario DISIMaster, then put it in your file. You never want to put the worst case scenario DISIMaster in your papers, whether it's responding. You're not doing the job for the other side, right? You're doing your client. But have that initial worst case scenario DISIMaster, present it to your client first, then work on some of the better ones and include one or two in your proposal. If there really aren't major issues in dispute, just include one. I do recommend an attorney declaration when a DISIMaster is attached to provide some foundation for the court as to how that DISIMaster was calculated. It lends some credibility to it. And if you're doing an attorney fee declaration anyway, it's very easy to say in one paragraph with a heading that says DISIMaster calculation. I prepared the attached DISIMaster report. It just lends a lot of credibility to it, and judges who aren't familiar with family law, maybe they're a little bit new, they're going to rely on a lawyer who's done the analysis for them than just trying to do it off the seat of their pants. When you're opposing a request for order, always consider evidentiary objections. As I said before, many, many times you're going to get a declaration from the other side that is filled with hearsay, filled with items that lack foundation, opinion, conclusion. It's just a complete mess. Now, in considering whether to do evidentiary objections, which are due at the same time as your responsive declaration, don't always do them and don't object to everything. Judges get really annoyed when you object to everything. Be careful about it. If there are just a couple lines in the declaration that are annoying, fine, the judge is going to get annoyed anyway, so you don't really have to object to it. But if they're attaching as an exhibit your client's medical record, you've got an issue. I've had that happen, and I've had to do an evidentiary objection, and you have to do them in writing, and you definitely want to look at Rule 5.111C. These evidentiary objections are really critical if you want to get an exhibit out. But if there is text that you actually want to have removed, you're going to have to do line items and a proposed order on those evidentiary objections. It's a lot of work to do. I don't do them in most cases, but once in a while I'll see an opposing or a moving paper that is just so inflammatory that I'm really going to have to do those. So consider that every time you're opposing a request for order. How about the reply? Do you have to do a reply if you're the moving party and the other side has filed a responsive declaration? No, you do not. They are not required. They are completely optional. Bear in mind that judges have very little time, and if your reply is nothing more than a rehash of your moving papers, it's going to annoy the court. You are limited to addressing issues set forth in the responsive papers. If there is something at issue in the responsive papers that you really do feel needs to be addressed, address it, but keep it short, keep it sweet. This is not another bite at the apple, and judges are really annoyed by them. What if you get sandbagged? What if the other side was the moving party? You did a perfectly fine responsive declaration that pointed out all the inadequacies of the other side's moving papers, and all of a sudden they decide, oh wait, we need a lot more evidence to prove up our motion. And their reply is now pages and pages long, filled with all new attachments, all new exhibits. You've basically been sandbagged. Well, the first thing you do is a last-minute set of evidentiary objections. But in addition to that, you're going to have to request a continuance in a lot of cases because you're not going to be able to respond properly, and it's just not fair to you. Cite In Re Marriage of Hofmeister. It's cited in your outline. It's a great case that basically says if the other side has just gone overboard, you can get a continuance. I've had some judges just completely strike a reply declaration that was either late filed or contains information that wasn't within the scope of the moving papers. So consider moving to strike and or requesting a continuance. Request for hearing, witness list, meet and confer. Should you request an evidentiary hearing? Now you can. After the Elkins case, new Family Code section came out, 217. The court has discretion to have an evidentiary hearing. You can ask for one. You won't always get one. Depending on the issues in dispute, custody cases, no problem. But financial issues, they don't really have to give it to you. Why would you want an evidentiary hearing? Ask yourself that question. I heard Judge Lewis say this is the worst thing to happen to you lawyers in a long time, because now you're no longer going to be able to shield your clients from themselves. I mean, think about it. Your declaration paints this pretty picture. You can wrap your client in a bow. You put them on the witness stand. You have no idea what's going to come out of their mouth. It's often venom, anger, hate, rage, or crying, none of which really impress the court, even though they think it will. So what you really want to do is measure whether to even request one. A real disadvantage of requesting an evidentiary hearing is that they take a long time, and courts generally won't have the time to have an evidentiary hearing on the hearing date set for your request for order. The judge will ask you for a time estimate. If you say 1, 2, or 3 hours, you're looking at coming back in 3 months. In a lot of cases, your client needs to understand that. So try to get everything in on the declarations. Number one, because you might not get one. Number two, because your client probably wants that relief sooner rather than later. However, if you're defending a request for order, asking, for example, for financial relief from your client, you may want to consider requesting an evidentiary hearing simply to set it out for a few more months to see if you can settle it. Well, that's where you serve a witness list. That's FL 321. Be sure to include whatever witnesses you think will testify, what the scope of the testimony is going to be. If there's a custody case, be sure to have your client complete custody orientation. In Los Angeles County, there's an online program, Our Children First. In Ventura, there's an orientation they have to attend. Make sure they've got their ducks in a row so that if you go to the hearing and your client hasn't completed Our Children First, which can be done in a matter of hours, the judge might continue the hearing, and your client's going to be paying you fees to sit there, and it hasn't been done. Make sure the mediation gets done. Make sure your client gets to the mediation and completes it. Because again, they won't rule on a custody matter in most cases without that having been done. Now, settlement options. Obviously, you should try to settle every case. You should try to send a settlement letter with your request for order. You should also send a proposed stipulation with your request for order, especially if you've got a pro per on the other side, because they get horrified when they receive these. And if you give them the option of just signing on a dotted line and avoiding litigation, you've just upped your chances of settling very early on, even before they've had to file a responsive declaration. So I include a settlement letter, very conciliatory. Take Teddy Roosevelt's advice, which is speak softly and carry a big stick. Okay? So you've got a really great request for order. They're probably going to have a heart attack. Include a nice cover letter. Dear so-and-so, I represent your soon-to-be ex-spouse. We'd really like to work it out. We hope we don't have to go to court. And by the way, here's a proposed agreement. If you have any questions, please call me. You've already fulfilled your meet and confer requirement, which you have to do anyway with any request for order. And be sure to meet and confer. Pick up the phone, call. The biggest mistake attorneys make is they wait until the day of the hearing and assume that they're going to be able to meet and confer with the other lawyer the morning of, when the other lawyer is going to be 10 minutes late, stuck in traffic, and the judge is already calling calendar, and you're standing up there, and the first thing the judge asks is, "Counsel, have you met and conferred?" No, Your Honor. Well, you need to do that. Well, right away, the judge is mad at you, even though you showed up on time. So don't wait till the last minute. Don't be the guinea pig. Go ahead and meet and confer. Pick up the other lawyer, or at least document your efforts to meet and confer. You should try to settle. Sometimes you can settle a case through mediation. The court budgets are really tight right now, but sometimes you can get a volunteer lawyer help you guys settle your case on the day of the hearing, but those resources aren't always there. I always recommend a four-way settlement conference, even if it's a venting session where everyone's yelling and screaming, because they're getting it off their chest. Don't resist the temptation to keep everybody completely at arm's length. I have found many cases that never, I thought in my wildest dreams, would settle. But as soon as we got people around a table, having a cup of coffee, and going through things, and developing a personal relationship, it really made it a lot easier, and we were able to hammer a lot of things out. As long as it's just letter writing and contentiousness, nothing gets done. And the fee bill goes up, and often you don't get paid those fees. The bigger your fee bill, the less likely they are to get paid. You're much better off doing a case for $2,500 to $10,000, getting in, getting out, getting it done, getting paid, and going on to the next one than having a $5,000 case turning into a $20,000 case and you only getting paid the $5,000. So keep that in mind. You have a lot of incentive to settle your own cases just to ensure you're getting paid. There are special rules for restraining orders. I'm not going to go into that today. And also I was going to talk a little bit about bifurcation. All I want to say about bifurcation is this. It's a great idea in a lot of cases where you have major issues such as validity of a prenuptial agreement, the date of separation. If there's a huge dispute, if you're only talking a month difference, don't worry about it. But if there's a 2 or 3 year date of separation issue, and you've got a Berrigree type case where somebody's doing laundry or they're having sex 2 years into the separation, you may want a bifurcated issue there. So you're going to have to do that request for order. There's a special attachment you do for that, but I do recommend it. If you're going to bifurcate marital status, bear in mind that there are declarations of disclosure that have to be done first. So again, at the beginning of the case, try to get your ducks in a row. If your client comes to you and says, well, I know we haven't resolved property, but when am I getting divorced? Don't I automatically get divorced 6 months later? Half of my clients think that. They just, I don't know where, I don't know what TV show told them that, but they think they just get divorced in 6 months, and there's a lot more to it. So prepare them for how long it takes from the time even a stipulated judgment is submitted, sometimes 4 months, to the time it's entered. So they don't just rush. I've had people already trying to plan their next wedding date. They're just gluttons for punishment. And they're going off right onto their next wedding date, and they don't realize that their divorce may not be final for quite a long time. So prepare them for how long it really takes. And so that's the gist of my presentation. Questions? Have I answered them all?
I had a question on expenses, but you did touch on it subsequently.
Yes.
I just wanted to repeat what you said. You said in terms of if you're the payer party, you want to minimize your expenses?
Absolutely. If you're the payor party, especially if your client is self-represented, self-employed, if their monthly expenses are $10,000 or $15,000 and they're only reporting $5,000 a month in income, that's a real problem for the court. So the first thing I tell my clients is reduce your overhead. They hate to hear that. I have clients driving, Range Rovers at $1,000 a month lease and living in a 5,000 square foot house where it's just them, okay? And we're up against a support. I tell them, you need to minimize yourself. My own father, I will say, was involved in a divorce case with my stepmom years ago. And he reported very low income, but he drove a Ferrari. This was a problem, and a photograph of his Ferrari was Exhibit A, and he got clocked. So I can tell you from personal experience, I tell my clients, you need to start downgrading. That Mercedes needs to become a Volkswagen. That 5,000 square foot house needs to come down, or you're going to get clocked in court. They don't want to hear it, but it's very valuable. So, and that's, yes, sir.
Petitioner, even after you ask him many, many times, won't give you a preliminary declaration of disclosure to bring a motion to compel.
Absolutely. Family Code Section 2107 lets you do that, and there's a special judicial counsel form that I've mentioned in my outline that you can use to bring that to compel it.
Sir, what was the question again?
Can you compel a declaration of disclosure? And absolutely. You do that with a request for order. But request it first and make sure you've done yours first. Because we have cases that have come down that say, if you haven't done yours, you have no standing to demand the other side do it. Exactly. Do a motion. Yeah. Yes?
I didn't know, you were talking earlier about adding an exhibit or a declaration from a vocational expert or a forensic. Can you do that without having them appointed by the court?
Absolutely. Yes, the question was, can you include a declaration from a vocational expert or a forensic expert in your moving or responding papers without having that expert appointed by the court? The answer is yes, absolutely. You can hire as many experts as you want, and you don't have to rely on A730. There are many cases where no 730 ever gets appointed, which is even better because you're the only one with an expert.
So in that scenario, present a declaration, but you should have that person there to be able to testify, or else?
I have mine on call because, as I said, in most cases when you show up to court, the judge has 5 minutes for you and isn't even going to be doing a true evidentiary hearing. Sometimes the judge is going to make a decision on declarations alone and you've already got yours in. But if there's going to be an evidentiary hearing where the other side wants to cross-examine your expert, I have them on call. Because sometimes the judge will say, okay, I'm going to prepare for your expert to testify, but come back at 1:30. So instead of paying them for a full day, I only have to pay them for a half day. They come in for a quick hour, they get cross-examined, they testify, they're fine. But I always have my experts on call, but I don't have them come in because I don't want to waste my client's money, because in 90% of the cases, it's either going to settle at the courthouse, settle before the day of the hearing, or the judge isn't even going to have time for an evidentiary hearing that day.
There was an RFO, though, you have these declarations attached to your RFO.
Yes, and I recommend tabs, customized tabs. I use a company called Legal Dimensions, but I have customized tabs for my own declaration. I have a customized memorandum of points and authorities. I have a customized income and expense declaration tab. I have a customized DISA master report tab, expert witness declaration, and even petitioner's declaration and respondent's declaration. I have pre-formed tabs, so I don't have to sit there and type at the last minute. I throw it together, and it's out the door.
What's the company? I'm sorry.
Legal Dimensions. Thank you.
Thank you.
All right.